My name is David Carpenter. I'm a partner in the firm's litigation and trial practice group. Today I'm going to talk about the Federal Telephone Consumer Protection Act, better known as the TCPA, what the statute has become, and steps that companies should be taking to avoid its pitfalls. TCPA was introduced in 1991 to prohibit certain practices using telephone equipment for marketing or solicitation purposes. In other words, it was enacted as the anti-telemarketing statute. But over the greater part of the past decade, it has become clear that no industry is immune from the TCPA. It has grown from the anti-telemarketing statute to create a cottage industry for class actions, with such lawsuits being filed against pharmacies, retailers, consumer product groups, cable companies, cell phone service providers, social networking sites, and even sports franchises. The TCPA regulates calls or text messages placed using an automatic telephone dialing system, or an ATDS, or using artificial or pre-recorded voice. Under the TCPA, it is unlawful to place a call or send a text message to a cell phone using an ATDS or artificial or pre-recorded voice without the prior express consent of the recipient. And if the call or text message constitutes telemarketing, the burden is even greater. The caller must have the prior, express, written consent of the recipient, which introduces a whole host of additional requirements. TCPA provides for statutory damages of $500 or $1,500 per call or text, and the damages add up quickly. If a company initiates a text marketing campaign to only 1,000 of its customers without the proper consent, it is looking at minimum liability of $500,000 for simply sending one text message. And the results in these cases are often staggering. The largest class action settlement in a TCPA case to date is $76 million. And the Georgia Court of Appeals once affirmed a $459 million judgment in a TCPA case. The statute itself is difficult enough to comply with, but courts and the applicable regulatory bodies have made it even more difficult by strictly construing the statute in favor of consumers and against businesses who are trying to lawfully communicate with their customers. The question of what constitutes an ATDS under the statute is constantly in flux, with varying interpretations from courts, practitioners, and the FCC. As a result, a company should always assume that its dialing equipment is an ATDS and seek to obtain the broadest consent possible from its customers. But even if a business takes the proper steps to obtain the appropriate consent from its customers, it still faces a number of potential minefields that can lead to liability. There is a risk in trying to call an older customer at a new number, as you may only have the consent to call that customer's original number. There's a risk in dialing a wrong number or reaching an unintended recipient due to human error, either by the customer or by a company employee. There is also a reassigned number risk. Even if a company has the consent to call a customer at a certain number, that consent disappears if the number is transferred to a new user. The risks posed by the TCPA and the prevalence of TCPA lawsuits make this an issue companies cannot ignore. Before a company finds itself facing the inevitable TCPA lawsuit, it should conduct a full audit of its business practices to ensure compliance with the statute. Alston & Bird has a full team of attorneys across its offices with experience counseling clients on TCPA compliance and litigating TCPA cases of all sizes and flavors.